everyone, this is Christine with Gals and Guns. I wanted to talk to you real quick about some information that's going around on the internet and also reported by several news agencies and the TV that is not actually correct, at least not for every area. Okay, post office parking lot decision. A lot of people thought that the ruling made by the Colorado 10th Circuit Court applied across the board since it was a federal post office. It does not. According to Texas Law Shield, that decision does not apply in the state of Texas and probably not in many other areas either. So what it was is it was a decision that was based on specific criteria, and the criteria that was taken into consideration was criteria that was specific only to that particular post office in that location, so it does not apply. Basically what Texas Law Shield has said, that it's a good start and it can perhaps, that decision can perhaps be used to take to court in other states and in other areas. The Colorado Federal District Court decision, the case in question is Bonaty et al. Versus the United States Postal System. In this case, the court was asked to make a very specific ruling. The man named Tab Bonaty wanted a ruling as to whether or not it was legal to keep a gun in his car while he was at the post office. That is one of the few places, because it's considered federal, that you cannot have your firearm in your vehicle, even in the parking lot. Okay? He was challenging the application of 39 CFR Part 232.1, okay? Which reads as follows: weapons and explosives, and I know you've all seen this on the door when you go, if you go to the post office. Weapons and explosives. No person while on postal property may carry firearms, other dangerous or deadly weapons, or explosives, either openly or concealed, or store the same on postal property except for official purposes. In light of the law above, one should consider the very particular circumstances. This case was in Avalon, Colorado. The post office does not provide delivery to the public. They provide free post office boxes to the Avon residents because they have no delivery. These post office boxes are the only method for them retrieving mail. The judge recognized these facts in his decision, which only apply to this post office particular facts and none other. Yet, okay, so we say yet because it's not to say that they can't apply it to others, but at this point it has not been. Further, the judge pointed out additional factors to consider in determining whether or not to allow firearms in cars, trunks, etc. i.e., is it fenced? Is there a gate? Are there signs imposing time limits or stating that vehicles are subject to be searched? Are there outside mail receptacles for the patrons? What type of government business is done there, i.e., loading of post office vehicles, etc.? And do high numbers of people congregate at the post office for other purposes? So, I'm not sure what exactly these particular questions made in one way or the other towards this case, but that was some of the questions that they were asking. The U.S. District Court of Colorado held that the concealed license holders are allowed to have a firearm in their locked trunk or have it otherwise secured in their vehicle under these circumstances. This does not mean a person can carry concealed on their body in the parking lot or open carry. Okay? And again, it was specific to the post office in Avon. Okay? Was there a precedent in the ruling? Does the ruling set any legal precedent for any other part of the country? According to the lawyers at Texas Law Shield, no. Precedent is going to be a rule, guideline, or other legal principle established by case law that is binding on other courts when it is a case with similar issues or facts. To put it in another way, precedent is best illustrated when a court makes a decision guided by previous rulings. With this said, there are two types of precedent, horizontal and vertical. Okay, and we're not going to get all into that, but basically they can look from one court at the same level to another court, or they can take it from the state court at the 10th Circuit and maybe try to take it to federal court, so on and so forth. Okay? So, it could help, but it has absolutely no legal standing. It can get complicated because the federal appellate level courts are divided into many different circuits. Okay? Again, the bottom line is, it doesn't matter if you see anything that says that yes, you can carry in a post office or in the post office parking lot, you cannot. Okay, it was information put out falsely, and a lot of the stories are being titled, "You can now carry in the post office parking lot, new court decision." False information. And again, as a concealed carry holder, you are responsible for, following the law, and false information is not going to hold up in court. It doesn't matter if you tell them, well, I read it on the internet. So again, know your law. All right? Just a little information to make sure we don't get caught up in something we don't need to.